welcome everybody to this seminar organized by the Center for Comparative and Public Law. I'm very pleased to introduce, or I think you're actually well known to, to most of the audience already, but Mara Malagodi, who is no stranger to the center and to the faculty. She's, we're very lucky that she's contributed a lot to as a visiting fellow to the center, and also on several projects with a number of colleagues in the faculty over the years. She teaches at City Law School at the University of London and specializes in South Asian law as a comparative constitutional lawyer, and focuses in particular on Nepal, well, and also India and Pakistan. And I didn't know this until I read her bio on the poster, but she's also an award-winning documentary filmmaker, and she is here this semester teaching a course on law and film in the faculty. And David Vitale,
yeah,
close,
good.
Okay, is visiting just for a few days. We're very lucky to have him. He teaches at the School of Law at the University of Warwick. He's also a constitutional lawyer, but his work intersects with political and social theory and social rights. He's clerked for judges in Ontario, Canada, and also at the Supreme Court in Israel. And they'll be speaking on what I find a very fascinating, cutting-edge topic. They've chosen an excellent title, Lost in Transformation, Social Rights Under a Contradictory Constitution. So without further ado, please join me in welcoming Mara.
Thank you so much to Kelly and to CCPL for hosting us. It's always great to be back and spend time at HKU. And to everyone who's in attendance, I know it's a busy time of the year with end of term and so on. So we really appreciated you joining us. So what we want to do today is offer some preliminary thoughts on this joint project that Devi and I have developed over the last few months. And we're going to talk about the notion of transformative constitutionalism, and most importantly, its limitations. And we'll be exploring this topic by looking at the particular case study, which is the case study of Nepal, and in particular, the recent constitution-making experience in Nepal and the outcome of that process, which was the 2015 constitution. So, as I said, this is work in progress, so cheekily, we would like to use you as a sounding board for our ideas and to test some of the hypotheses at this early stage. By way of background with the project, David has conducted research for many years on public trust in government and social rights. And I have a long interest in Nepal, and recently, last year, I took part as a trainer in 2 sessions in Kathmandu for emerging legal practitioners on economic, social, and cultural rights. Especially with regard to litigation. So when I came back to the second training, David and I started chatting, and we realized that there was quite an interesting intersections between our respective work. So here we are, and I'm going to hand over to David to take you through the first part of the presentation.
Okay, so thank you all for coming, and I second Mara's thanks to everyone involved for organizing. So just to give you a bit of an outline, so we're going to proceed in kind of 4 steps. First, I'm going to start with kind of a basic introduction to this concept of transformative constitutionalism, for those of you who are not familiar. And included in that, we're going to try to flesh out a bit what are the key elements of this idea of a transformative constitution. And of note, we intend to present this idea that a key part or characteristic or hallmark of a transformative constitution is the inclusion of positive rights and, importantly, social and economic rights or social rights provisions. Then I'm going to talk a bit about this idea of transformative constitutionalism and its relevance particularly to the judicial enforcement of social and economic rights or social rights, and specifically around kind of the South African context and the role that it's played in social rights enforcement in that country. In the third part, Mara will talk about the case of Nepal and its constitution-making experience, and she will identify what we think is a gap in the transformative constitutionalism literature. And so she will use the Nepali constitution to suggest that rather than it being a transformative constitution, it's what we consider to be or call a contradictory constitution. And then in the final part, Mara will discuss in brief some of the implications that we see of our research including for the Nepali courts and their enforcement of social rights, as well as potentially for jurisdictions outside of Nepal, especially for newer constitution-making experience and trends that we suspect may happen in the future. So to start with this idea of what exactly is a transformative constitution. So the literature makes fairly clear that there is no universal definition of, or universally accepted definition of a transformative constitution. The literature is full of various characterizations, conceptualizations, definitions, with slightly different kind of suggestions. But I think broadly speaking, in a recent book, James Folks gives I think a fairly good broad definition. He describes it as a blueprint. So a transformative constitution is, quote, a blueprint for a better society and a means of achieving that better society, above all, via rights of broad, positive application. So it's this idea of moving towards a better society, towards a more positive society. The language of transformative constitutionalism stems in large part from this 1998 piece that was written by an American scholar by the name of Carl Clare in a South African journal on human rights. And in that piece, Clare talks about the South African context, specifically the relatively new at that point South African Constitution, and he drew on the work of a very famous South African scholar by the name of Etienne Morenik, who saw the democratic transition in South Africa as being what he called a bridge from authoritarianism to a new, quote-unquote, culture of justification. So he said, or he described it as a culture in which every exercise of power is expected to be justified. So Clare in that piece goes through quite some detail about how he sees transformative constitutionalism, and I'll set out is kind of the bulk of his kind of conceptualization in a quote. So he says, by transformative constitutionalism, I mean a long-term project of constitutional enactment, interpretation, and enforcement committed, continue on, to transforming a country's political and social institutions and power relationships in a democratic, participatory, and egalitarian direction. Transformative constitutionalism connotes an enterprise of inducing large-scale social change through nonviolent political processes grounded in law. I have in mind a transformation vast enough to be inadequately captured by the phrase reform, but something short of or different from revolution in any traditional sense of the word. In the background is an idea of a highly egalitarian, caring, multicultural community governed through participatory, democratic processes in both the polity and large portions of what we now call the private sphere. Now, given the fact that this idea of transformative constitutionalism was coined in the South African context, and it tends to be associated with the South African Constitution and the jurisprudence of the South African Constitutional Court. So I will be spending a significant portion of my portion discussing the South African context and the way in which transformative constitutionalism has been understood in that South African context. And in particular, it's had an important influence when it comes to social and economic rights. So one of the key ways in which transformative constitutionalism has been defined or understood is in fact by what it is not. So transformative constitutionalism is often distinguished from what's called a preservative constitution. And so preservative constitutionalism understands constitutions as constraining state power and safeguarding individual freedom. So and that freedom being understood in formal negative terms. So Clare, for example, in his piece, he described transformative constitutionalism as, quote, an unmistakable departure from liberalism, as contemplated in classic documents like the US Constitution. Now, a transformative constitution, in contrast, it doesn't seek to preserve. It is, in fact, a break from the past, or break with the past. And that break comes along with an embrace of a new, different kind of constitutionalism, this idea of transformation, this idea of a better society. And so people have described it as being both backward-looking and forward-looking. It's backward-looking because we're trying to break from the past, and forward-looking because we're trying to build that better future. And so, as I kind of alluded to earlier, it's often in the South African context, the metaphor of a bridge is used. So a bridge kind of from the past to the future, although some have criticized the use of that bridge or that metaphor because it doesn't really give an indication of kind of going forward in terms of where it takes us. It kind of suggests that there is an end point when people have said that there's not really an end point. Now, based on our reading of, as I mentioned, there's no really universally accepted definition of transformative constitutionalism, but we kind of want to identify three kind of central or key elements of a transformative constitution in order to aid our discussion today. And so those three elements are, well, first of all is the first one is an explicit promise to change. So we have this indication of, usually it's contained in a preamble or a postamble. It's a commitment to some sort of change, to some sort of transformation. And so a classic example here is we look at the preamble to the Constitution of South Africa. It reads, "We, the people of South Africa, recognize the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic, so as to," and then describe a couple of key elements. And the first one is particularly important for transformative constitutionalism. And it says, "Heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights." The second being, "Lay the foundations for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by law." The third being, "Improve the quality of life of all citizens and free the potential of each person." And the fourth being, "Build a united and democratic South Africa, able to take its rightful place as a sovereign state in the family of nations." So in this explicit promise to change, or in this preamble, we see this kind of language of breaking from the past, building towards a better future, specifically in that first element where we see that kind of heal these the divisions of the past and establishing that better society. The second element or key element of a transformative constitution based on the literature is a commitment to this idea of substantive equality. And so I'll get to that quote in a second, but so it's well recognized in the literature that substantive equality really is key to a transformative constitution. And so a formal notion of equality is not considered transformative because, in fact, a formal notion of equality can actually serve to entrench rather than challenge structural forms of domination and vulnerability within society. And so it's been well accepted, specifically by the courts in South Africa, that substantive equality and the commitment to substantive equality is central to truly transforming a society, to truly taking on a transformative constitution. And so I have here a quote from the former Deputy Chief Justice of South Africa. Hopefully I pronounced his name correctly, but it's Dikong Moseneke. And in his fourth Bram Fisher Memorial Lecture of 2002, he summarized this key or this importance of transformative or of substantive equality to transformative constitutionalism. And so he started off by saying that central to this idea of transformation in the Constitution is the achievement of equality. Then he goes on and talks about transformative jurisprudence and says that transformative jurisprudence would support a commitment to substantive equality. It requires an examination of the context of the violation of the right and its relationship to systematic forms of domination within a society. It seeks to reorder systemic and entrenched disadvantages at the same time as it aspires to optimize human development, and then concludes that within the South African Constitution, that the primary purpose of it is to intervene in unjust, uneven, and impermissible power and resource distributions in order to restore substantive equality. And beyond this, there's repeated references within the literature to substantive equality and how you really can't truly achieve transformation. You can't have a transformative constitution if equality is not of the substantive form, if you're not achieving a substantively equal society. The third element is broadly speaking, is the inclusion of positive rights, and of particular relevance is the inclusion of social rights provisions. And the idea here is that, as I mentioned before, a transformative constitution is intended to be distinguished from a preservative constitution. And so preservative or liberal constitution is this idea of kind of minimizing state interference, whereas a transformative constitution is to get the state involved, and a key part of that is to provide these positive rights, including rights to social goods and services. So we think of things here like the right to healthcare, the right to education, the right to food and water. And so, again, using the South African Constitution as a key example, it in fact has in its constitution, specifically in sections 26 through 29, these express or explicit rights, social and economic rights. So section 26 covers the right to have access to adequate housing. Section 27 covers a whole range of rights, including the right to healthcare services, sufficient food and water, as well as social security. Section 28 is a number of social rights dealing with the rights of children specifically, and then section 29 protects the right to education. And particularly important, which I'll talk about in just a second, but is the idea that not only are these rights contained within the Constitution, but they're also recognized as justiciable. And in fact, the South African Constitutional Court has repeatedly recognized that in fact they are justiciable, that the court has a role to play, and a very important role to play in enforcing these social rights, dating back at least to the Group Boom decision, and in fact before that. So, giving that kind of broad background of what constitutes a transformative constitution, the next question that I want to address is, well, what is the relevance of transformative constitutionalism to this idea of judicial enforcement of social rights by courts? And so, as I mentioned earlier, it has a particularly important relevance to play in the judicial enforcement of social rights. So, and here I want to draw on, I think, what I find a particularly useful or helpful distinction that has been drawn by James Folks in that book that I mentioned earlier. And he draws a distinction between the fact that transformative constitutions serve two purposes, or have two kind of elements. One is a transformative constitution, or transformative constitutionalism refers to what a constitution is, and that's the idea of looking at the text, and asking, is that text transformative? And so that's what I've been talking about up to this point, this idea of, does it have these elements, these key features that make it transformative? But there's the second element, or the second component, which is transformative constitutionalism talks about or focuses on what ought to be, and how the state, how the different branches of government, how potentially even private parties should realize the transformative potential within a constitution. And so we have this distinction between the is and the ought. And so this idea of the ought, as I mentioned, it kind of focuses on a number of parties. You can look at, for example, the various branches of government, the executive, legislative, and the courts, and because they all have obviously a role to play. But the latter element, this ought element, really, there's been a dominance, especially in the South African context, to talk about courts and the role that courts can play in realizing the transformative potential of the Constitution. So in a jurisdiction like South Africa, which will be distinguishable from Nepal, which Mara will talk about in a second, the is element, that is question, is really not contentious. It's generally accepted that the South African Constitution is transformative. The Constitutional Court, as well as the lower courts in South Africa, have recognized it is transformative. And so most of the debate has been around this ought question, this question of what can the various branches of government, and especially or particularly what can the courts do to realize the transformative potential within the constitutional document. And this idea of transformative constitutionalism and transformation has really had a significant impact on the court's understanding of their role in enforcing constitutional social rights. So, just to give you kind of a background, so many of you will probably already know or may know, but the judicial enforcement of these types of rights, these constitutional social rights, is a highly contentious topic because it has a long-standing debate. The debate, started probably back in kind of at least the 80s to 90s around whether or not social rights are or should be justiciable. But in the last 10 to 15 years, the debate has shifted, with jurisdictions like South Africa accepting social rights justiciability, as well as a number of constitutions globally including these provisions and recognizing the justiciability of these rights. So the debate has shifted to a question of how these rights can and should be enforced, rather than whether or not they're the domain of courts. Now, what lies at the center of that debate in both forms, the justiciability debate and this current how or judicial approach, as I call it, form of the debate, is the separation of powers. So including whether social rights, which address matters of social and economic policy, are those things the proper domain of the courts, and how far can courts go into that domain? Now, as I mentioned, in the South African context, this notion of transformative constitutionalism has played a really important role, not only in the court's overall kind of approach to enforcing constitutional social rights, but in more broadly its understanding and its respect for this idea of the separation of powers. So I just want to give you two examples of the way in which kind of you see this intermingling between this notion of transformative constitutionalism and this idea of the separation of powers or the enforcement of social and economic rights. So the first is a quote that was given by the former Chief Justice of the Constitutional Court, Pius Lenga, in a lecture that was given in Stellenbosch University in 2006. And so he says, talking about kind of broadly speaking transformative constitutionalism, he said, "The Constitution demands that all decisions be capable of being substantively defended in terms of the rights and values that it enshrines." And so here, and then he goes on, and this part is particularly important with respect to the separation of powers. He says, "It is no longer sufficient for judges to rely on the say-so of Parliament or technical readings of legislation as providing justifications for their decisions. Under a transformative constitution, like the South African Constitution, judges bear the ultimate responsibility to justify their decisions, not only by reference to authority, but by reference to ideas and values." And then I think of particular importance, he goes on and says, "This approach to adjudication requires an acceptance of the politics of law. There is no longer place for assertions that law can be kept isolated from politics. While they are not the same, they are inherently and necessarily linked." So we see this idea of, potentially its understanding of separation of powers, its understanding of the relationship between politics and law, its understanding of how far courts can go in enforcing constitutional rights, which probably does and includes constitutional social rights. Then 2 years later, in a talk that he gave as a keynote lecture at Oxford University in 2008, he talked about specifically this idea of transformative constitutionalism and its relationship to social and economic or social rights. And he says that, talking about what constitutes transformation, he says, "There are at least two parts of our commitment to change or our transformation. The first being a pursuit of a truly substantively equal society." So this idea that I mentioned, the second element of what we see as a key part of a transformative constitution. And he says, "We recognize that the government bears duties to refrain from taking steps that restrict people's ability equally to exercise their rights and freedoms. But equally importantly, we recognize that the government also bears duties to take positive steps to protect, promote, and fulfill the equal freedom of the people. Thus, South Africa's pursuit of substantive equality requires both state prevention of status-based discrimination and state promotion of distributive justice. This in turn means a radical commitment to the state provision of services to all in the leveling of the economic playing fields that were so drastically skewed by the apartheid system." So we see this true commitment as part of the transformative constitution towards a substantively equal society and substantive equality. And then he goes on and he says, two of the most important means to these ends, including this end of substantive equality, are in South Africa affirmative action measures, and importantly, the entrenchment of socioeconomic rights. So we see again this intermingling between social and economic rights and transformative constitutionalism, including the separation of powers, including this idea of substantive equality within it. So this is just to give you an idea of the importance that transformative constitutionalism has had on the court's understanding of the social rights in the South African Constitution. So I'll turn it over to Mara and she'll talk about the Nepali case.
Thank you. Thank you very much. So to move on and then think about how this discussion that David has presented so convincingly, how does it fit within the Nepali case study? So what I've done here, I'm just giving you a snapshot of what the current Constitution of Nepal, the 2015 document is. So I'm engaging here very much with David's questions about what a constitution is, that aspect that in the South African context is not controversial, is not contentious. In Nepal, it is already by looking at a textual level. So also, why is that interesting? So when we're looking at the 2015 Constitution of Nepal, it is a post-conflict constitution that really made a promise, as you can see from the first point, of delivering profound social change. So you do have, in a way, that expectation that comes from the first element of transformative constitutionalism. So let me explain a little bit more about this constitution, and hopefully you see why it kind of fits the promise that transformative constitutionalism makes. Well, first of all, you had in Nepal 10 years of civil war. Between 1996 and 2006, the resolution of the conflict revolves around the delivery of a new constitution that will transform and resolve the grievances that were essentially at the heart of the Maoist insurgents' demands. You also have, more specifically, this idea that it will be a constitution, the seventh in Nepal history, drafted for the first time by the people's elected representatives. So you have a representative, democratic, constituent assembly that will draft this constitution. And also you have the core of the grievances that we had in Nepal since 1990 in terms of inclusion, the idea of bringing the different marginalized groups within the fold and the constitutional fold will be reflected, the struggles and the resolutions, in the text of the constitution itself. So if you look at, even in newspaper clips, political speeches at the time, even if you look at the comprehensive peace agreement, very much what's reflected under the first point is this mantra of social inclusion that will be delivered through radical state restructuring. Also, I have to say something about the specific context of Nepal and why this is relevant. So, Nepal is not as small as it is presented. It is small comparative to its big neighbors, China and India, but you have 30 million people and a staggering level of diversity. So we're talking about over 100 ethnic linguistic groups and caste groups. So 8 different religions with a majority which is Hindu, but an enormous amount of religious syncretism, different regional groups, and then of course questions of gender and sexuality having become very relevant in the last 15 years in the country. So the idea is that this historical form of marginalization for many of the social groups in Nepal would be resolved through the constitution-making exercise. So that's very much the message that was at the core of the expectations at that point. So if the first point in terms of what we expected from this new document is reflected in the declaratory parts of the Constitution, from the preamble to some of the directive principles of state policies and the formulation of some of the rights, when you actually focus on the notion of equality and you ask the question whether the 2015 Constitution square with that promise of substantive equality that transformative constitutionalism is supposed to deliver, then the answer is no. So let me just give you a few examples. So you have a constitution here that promised transformation of society and inclusion of all the groups, and then starkly discriminates on the basis of gender in matters of citizenship. So how do you square that with that promise of inclusion? You look at also in terms of the declaratory parts, and again, one of the contradictions, you have a definition of the state being secular, but you have an explanatory clause in the text that explains what secular means, granting a special place to Hinduism, in a particular version of Hinduism, which is a particularly conservative one known as Sanatana Dharma. That you read together with the right of religion, where you still have All Nepali constitutions have had that since 1959. You have a ban on conversion. So literally, if you translate from the Nepali text, it's a prohibition to cause someone to change their religion. And then you have, this is a new addition that kind of came out of the blue in the last stages of constitution making. So as David was talking about, affirmative action measures are one of the trademark features of transformative constitutionalism. Nepal has had that since the 1990 constitution, and it just expanded. So what's happening here? So you have the creation of a new category of a group that is entitled to affirmative action measures, and it's called Kasarya. Just to give you a little bit of background, we're talking about two caste groups, Bahun and Chetri. So that would be the Brahmins and Kshatriya. So you're talking about the two, in terms of religious status, the two highest groups. So just to give you a politically incorrect example, it would be like the South African constitution making white men a group entitled to affirmative action measures. In a way, kind of undermines and subverts the idea of historical redress, of marginalization, and redress to anti-democratic injury accumulated over the century. So that was particularly problematic. Again, so that's just in relation to equality. And then we move on and we ask the question about the role of social rights. So you have a very long list of social, economic, and cultural rights included in the chapter of fundamental rights, which means they are justiciable. So they're judicially enforceable. So what you have in Nepal, very much in 2015, borrows from the South African model of having these extensive rights recognized by the Constitution and included in the chapter. But, so that's why it's a yes and no. So you have that level of judicial enforceability, but you have an article in the Constitution itself, which is Article 47, that essentially limits the enforceability of rights. And I'm just going to share the formulation with you. So the article is called Implementation of Fundamental Rights, so it applies to all the rights under the chapter on fundamental rights. For the enforcement of the rights conferred in this part of the Constitution, the state shall make legal provisions as required within 3 years of the commencement of this Constitution. So on the one hand, we can all argue that that's just bad legal drafting because it's so vague that you essentially are not quite sure what you're going to do with the existing case law on social rights that Nepal has had pretty much since the mid-90s. You ask, well, what about the new rights that don't have quite an extensive load of case law supporting their interpretation? What are the courts to do when, since the promulgation of the Constitution in September 2015, for 3 years, there was no such implementing legislation, and the acts were passed in a rush within a week, and I was there. We got to preview the drafts of the legislation at the second workshop and the second training, with no public consultation, essentially curtailing quite significantly the inclusion of those rights. From a structural point of view, what you have, which is also significant, that is detrimental to this transformative idea of constitutionalism in the Nepali context, is that actually you have a significant weakening of the position of the Supreme Court, which is being the judicial body that has acted and implemented and interpreted social rights and the right to equality and many others pretty much since the mid-1990s. And the weakening of the Supreme Court comes in three forms. So you have the creation of the constitutional bench within the Supreme Court, which weakens the Supreme Court because they're the only part of the court which is allowed to essentially invalidate legislation, primary legislation, through judicial review. South Asian courts, because they have a history of judicial activism, they're really backlogged already. And the constitutional bench, because of the retirement ages of the judges, the composition changes all the time, which means you have such a backlog now that if you want to file any sort of case where the remedy that you require is the invalidation of primary legislation, you know that that avenue is practically close to you as a petitioner because of the backlog. The second element is the easement of impeachment. So essentially, since this constitution has come into force, we've already seen 2 attempts at impeaching Supreme Court justices. One failed at the first step. The second one, I think, made international news in 2017. It was the first female Chief Justice, of course, that was impeached until the Supreme Court in a bold move restated her. And then you have the third element, which has to do with appointment. So it's kind of a mix of an American and Indian style system where you have 2 layers of appointment, including parliamentary hearings committee that essentially have been veto nominations twice. So you have, on the one hand, this promise that the judges are going to be absolutely central to realizing these rights, and on the other hand, the Constitution cripples the highest judiciary. So what's interesting now in terms of practice, which is always fun to talk to practitioners, is that they're actually filing many more cases at high court level, and actually they're trying to litigate at district court level, which is the first instance level. So a lot of creative litigation, but this is not the picture that you would have for South Africa at all. Thanks, Dave. So if we look a little bit at the context and think about that relationship that David presented with relation to South Africa about social transformation and political transition, I just wanted to give a little bit of background to understand from a perspective, one of constitutional borrowing, so the movements that transformative constitutionalism has made worldwide just by looking at Nepal as a prism to observe this movement of the model. And then also to think about the role of the judges, and also to kind of set the scene for asking the conclusionary questions and what next. So if we look at Nepal specifically, what do we have in terms of the periodization that we need to look at is post-1990. So we're looking at the second redemocratization and the making of the 5th constitution of Nepal, small commission, quite interesting. I did my PhD on this, a lot of fun history with legal drafting here. And that's actually based on the Indian model. So what do you have here? It's a different inspiration towards transformational constitutionalism. So it's not the explicit commitment of justiciable social rights like we have in South Africa, but essentially you have the basis and the seed for that transformation. You have a significantly expanded role of the highest judiciary, especially Supreme Court, with judicial review of legislation and the borrowing of the public interest litigation model from India. So basically what's developed judicially in the Indian context is basically transcribed into the text of the constitution in Nepal, very similar to what's happened in Pakistan and Bangladesh. You have an extensive list of fundamental rights, but social rights in 1990 are not included in the justiciable chapter fundamental rights. They're slotted exactly like in India under the directive principles of state policy, which is basically an aspirational chapter of the constitution, which cannot be litigated in court, although we see that then the courts become really creative with their use, and essentially DPSPs become used to interpret fundamental rights. But then you have, even with that, exactly alongside the Indian model, the development of quite an impressive body of case law from right to food, right to water, and an expansive interpretation. So essentially judicial activism creates this body of case law in Nepal. Since 1996, for 10 years, you have the civil war with the Maoist insurgency. And the reason that I'm talking about the insurgency is to kind of link back to that promise of transformation. So the idea behind the insurgency from the Maoist political leaders was that the transformation that the 1990 transition brought about was not radical enough. So it was the idea that actually to bring a real transformation, we also need a new constitution. And that's very Nepali that you have a Maoist insurgency and peace talks fail because they want a new constitution, which is the quintessential bourgeois state institution. So I remember being very puzzled as an undergraduate living in Kathmandu in 2002, 2003, following all of this firsthand. So you have a comprehensive peace agreement, which is a very long document that explicitly commits itself, kind of almost echoing the South African constitutional language, and has an explicit reference to the inclusions of economic, social, and cultural rights in the new constitution. So we're kind of, I call this the beginning of the peace process is peak inclusion in Nepal. So everything is open, all sorts of discussion. It was the most exciting time to be in Kathmandu at all. That's the time I was doing my PhD fieldwork. So you have the passing really quickly in a not particularly inclusive process, but actually the outcome is staggeringly inclusive, which is the interim constitution of 2007. And that essentially encapsulate everything that David has talked about in terms of the South African Constitution. So then the question is, that constitutional moment withers away really, really fast. By 2012, when you have the dissolution of the First Constituent Assembly, the agenda for inclusion is being completely taken off the table. Then we come to 2015, 2 earthquakes, no progress on constitution drafting. Then you have national crisis, Indian enforced blockade of the border, so shortages of food, medicine, gas, everything. And the idea is that constitution making has to basically be fast-tracked. And inclusion and identity politics become an obstacle. So the idea is that national unity has to take over the agenda for inclusion and essentially substitutes it almost entirely. And that to us is significant, I think, because it's really the relationship then between equality, inclusion, and constitution making changes radically. At that point, so what is national unity? What's the price that you pay for transformation? So here, if we look at the terms that we've been using in the talk that David has been illustrating, so it's not a question of a preservative constitution, because the idea is not to kind of put forward the liberal model of constitutional democracy. You know, in a liberal constitution, you wouldn't have this kind of gender discrimination and this kind of forms of majoritarian populism in a way, which are enshrined, in which it's the identity of the majority that gets reinforced through the device of Hinduism and so on. And that's why we came up with the term contradictory. So I'm going to move on to our conclusions and offer a few thoughts. So first of all, the questions we've been discussing is, okay, so in a context like this, where you have a text, on the one hand you have a text that has all these contradictions, but you also have a body of existing case law, which is quite progressive, in which judges have been quite activist and in a way recognizing this need for transformation. What will courts do in this kind of context when you have profound internal ideological tensions and contradictions? And it's not just a question of looking at compromises within any constitutional text, because that's just the norm. Here we're talking about something way, way deeper. So one of the questions that I had was, when I was talking to one of the senior lawyers that lobbied for the inclusion of justiciable social rights and an extensive list in the last months of the constitution making, it was, well, what about the other shortcomings of the Constitution? In a way, if social rights are not effective, does that become a sort of fig leaf for the discriminatory forms that the Constitution has? Also, the question, and it was quite interesting, because when I discussed this within a global South context, social rights are not controversial. If you talk to judges, if you talk to politicians, there is the question of like, oh, but they're expensive, how do you enforce them? But per se, the idea is that, well, if you don't have anything to put for dinner on your table, then you don't really have civil political rights either, because you're starving. So in this kind of context, I think, social rights are increasingly included in constitutional texts, and there is quite a clear trend looking at recent constitution-making experiences. From South Africa in 1996, Kenya in 2010, Zimbabwe in 2013, Egypt has them in 2014, Tunisia, Nepal, so Myanmar in 2008, so quite a wave in terms of inclusion. But then, to me, it's like, then what does it mean? So you have a constitution like the South African one or the Kenyan one, which are clearly transformative. The Nepali one is not. Would Egypt be one of those, another comparator with Nepal? So with the surge that we're witnessing of regressive forms of ethnocultural majoritarianism and populism, which are reflected in constitutional arrangements, what are the courts to do with this? So what we suspect is that the Nepali constitutional experience is just the beginning of a long line of contradictory constitutions that we're going to see, and that it needs to be studied further. So I leave you with this depressing thought.
Thank you very much. We do have some time for questions, comments. Dan? Okay.
Yeah, thanks very much. I've got a couple of questions that are not very well formed, so forgive me for coherence. So one of the wow, sorry, I was worried. Things were coming out of the wall there. One of the things that I noted was this sort of elision between the Constitution and constitutionalism. And so I just wondered if you could say, so the Constitution is obviously, you know, the legal is, the text that's there, and constitutionalism is a whole set of other beliefs and aspirations that kind of come along and sort of give some buoyancy to the text and so forth. So does that distinction help understand what's going on in the Nepali context, or in these broader kind of situations that you were alluding to at the end, so that it's not simply a contradictory constitution but contradictory constitutionalism? And does that, if that's the case, that where is it understanding that latter and the reasons behind that, that's where the kind of work is required? And then there's the second question, which is probably just a result of my ignorance and misunderstanding of the extent of social rights, particularly in the South African context and elsewhere, social and economic rights. But one of the things that David, you mentioned in terms of the survey of transformative constitutions and transformative constitutionalism was a departure from liberalism. The South African Constitution, for example, is, I think it's Clare, isn't it, who says it's the first post-liberal constitution. And it's certainly, in the way in which he presented it, certainly there's a renegotiation of the distinction between the legal and the political there, and an expansion of the justiciability of aspirations that might normally or historically been consigned to the political arena, questions of policy around housing, education, and so forth. These become justiciable. The expansion of the legal, the kind of scope of the legal increases. I just wonder, how does the economic fit here? Because I know that one of the concerns about the reconciliation process in South Africa was the inability for economic redress, but the ability for political redress. So property rights were unchallenged in that context. So to what extent is, and in that case, it's a clear continuity of a liberal project, that the economic is kind of considered discrete from the political and the legal. So to what extent does transformative constitutionalism engage in that, engage more forcefully in that, in the economic? Does that make sense? Is that clear? Yeah.
I guess I wanted a bit more clarification on, because there's so many ways in which economic can be used. So, because one of the things we've discussed is
property rights, and
okay.
Thanks, Dan. So if I understand correctly, the distinctions that you have in mind is between the Constitution as text and constitutionalism as normative, but also as praxis. Did I understand that correctly?
I think it's much bigger.
So yeah, I agree. So the questions that I have in kind of small, cute question relating specifically to the case study is, well, we have a text which is clearly not ideal. Could be worse, but I think it's full of bugs. Essentially, it's just a result of bad drafting. Some of it is rushed, but also some of it is willfully bad drafting. I think, the contradictions were willfully put there. So what do you do with that when you come to the implementation of the Constitution? And I think the question will also be about the different actors that contribute to that. So first of all, of course, for us, the first question is, what are the judges going to do? Are they going to basically read out the regressive provisions out of it? But then you never know. It's kind of a Damocles sword. So essentially, if I look at the pendulum from 1990, so you have, just to give you an example, for one example, the place of Hinduism and how that was treated. So early case in 1990, you have a reference by the Supreme Court to that declaratory clause talking about Hinduism as the Hindu state. So it's not religion, a state religion or anything, it's just a definition of the state. But the court goes back to use that definition of the state to justify unequal property rights between men and women, because that's the traditional Mitaksara Hindu property system. So it goes back to that symbolism to justify substantively what's happening. You have then a movement to pure secularism under 2007 Constitution, but even then you had cases where you had applications to decriminalize the killing of cows as the sacred animals of Hinduism, and you still had the courts that wouldn't go that far even with a fully secular banner. Looking at what's going on in India, I think it became even more relevant after these elections with the rise of the Hindu right. You do wonder what's going to happen with a provision like that, which is symbolic, but that essentially reinforces patterns of ethno-cultural majoritarianism in the country. And how are the judges going to read that when it comes to a treatment of minorities? We know how that's been dealt with in India in some of the cases abysmally. So, that's one of the questions. What are the judges going to do? Then, you look at different levels, and of course you have implementation by the executive in terms of policy and so on. And that, one can only hope that perhaps federalization will kind of bring different tires. And then you have civil society, which actually I think is the most exciting of the aspects in terms of the actors and in terms of practice. You have a vibrant civil society. You have a lot of legal NGOs that actually just do this kind of work. They do public interest litigation on different areas, and you have many, many more coming up. My hope is that they'll be able essentially to litigate at different levels. So they got this pilot project, the NGO that I work with, Forum for Women Law and Development. So they're piloting in 5 districts litigation on social rights at district courts, so at first instance, to make sure that you have that kind of the redistributive measures. I don't know how that's going to play out, but I think civil society is quite strong in Nepal, so that perhaps they will breathe life into a certain version of constitutionalism which is transformative. But I think it's very difficult to tell.
With respect to your question about kind of this departure from liberalism, I'd have to give it a bit more thought, but one thing I wanted to make clear is just, so I think a number of commentators have talked about this idea that a constitution is not necessarily entirely transformative or entirely preservative. It's better thought of in terms of kind of having elements that are transformative and elements that are preservative. And so I'm thinking, for example, I believe Cass Sunstein has talked about this, and Tunis Rue has talked about this. And so kind of so by social rights, we're thinking of more positive rights, but there will be, I think, in any constitution, including the South African Constitution, certain negative or kind of preservative elements. But kind of the transformational side is particularly important around kind of these social rights, these positive rights, these rights to kind of positive provision of social goods and services like healthcare and food, water, because it is that departure. It's something that's not particularly accepted in the more liberal constitutions, and something that kind of focuses on this idea of distributive justice.
Thank you very much. I learned a huge amount and lots of thought-provoking ideas, particularly around economic, social, cultural rights, which we can discuss further. But I'm just struck with this idea of a contradiction, because and why you fasten on this idea, because all constitutions are contradictory in some way. So what makes these ones especially contradictory, I suppose, is my question. And that must be a matter of perspective, what perspective you take to spot the contradictions. So in standard liberal constitutions, there's a contradiction between free speech and privacy, all kinds of property and redistribution. And so from whose or from which perspective are these contradictory? Is there a kind of insider-outsider dynamic? Is it because it's within a way of explaining what you described as profound internal conflicts that seem to be, on the one hand, resolvable through the question of national unity, which was one of the ways that South Africa, that was such a prominent term in South Africa's transformation. So at what levels are the contradictions occurring? Because on one level, there are contradictions within the umbrella of national unity. On another level, there could be contradictions between the conflicting positions and the question of national unity. and that one version of that might be economic. So there's a question of contradiction, religious, secular, modern, not modern, whatever. And then there's a question of temporality, contradictory in terms of the past or the future. And the metaphor of the bridge is interesting because there are two ways across a bridge. So in that sense, lots more to think about, but I'm just to say more about this question of contradiction.
You want to take it? You want me to?
Sure, I can start.
Okay.
All right. So I'm going to answer specifically in the Nepali context and how the term came to us in discussions on this. So for me, in terms of the conflict, there is internal conflict. So of course, you had 10 years of civil war, but there is also societal conflict. And specifically for me, the contradiction comes from the promise of this constitution building exercise, which is there to deliver inclusion, supposedly. But then you have and remedy anti-democratic injury. So the idea is that it's a constitution that's gonna bridge the past in the sense of kind of compensating, so to speak, or moving towards a more inclusive future. And that's the contradiction, because you have that kind of language in some of the declaratory parts. You see the interviews with all the politicians, the best constitution in the world, it's super inclusive, that's the party line. We had an event in London with the ambassador. It's like, it's very inclusive, everyone, remember, it's inclusive. He actually said that. And you're like, well, it's not. For me, the point was that the promise and the people who felt that that promise and that trust was breached were marginalized groups. And we're talking from women who suddenly find themselves discriminated in 2015 on the acquisition and passing on a citizenship if they're married to a foreign spouse. It was the ethno-linguistic minorities that suddenly they can't get rid of this cow symbolism, and you have a criminalization of cow slaughter that carries a rigorous imprisonment sentence. You have this reference to Hinduism in a particular socio-political context, looking at what's going on to India, that does not bode well for everyone who does not conform to that kind of practice. You have issues with regard to federalism. I didn't touch upon that, but that was one of the pillars of transforming the state through federalization that recognized different ethnicities and groups, and that wasn't done in the way in which it was promised. So essentially, if you talk to leaders from the Janajati movement, Madhesi movement, Dalits, everyone will tell you, we got mugged. I think that's the expression that a number of people have said. There were all these promises, there were all these things up in the air. And of course, there has to be a degree of compromise, but on the demands that were really important, they lost on all fronts, almost. So that's why, even if you look at the earlier draft, so if you look at the work of the first Constituent Assembly, you can see that it was much more progressive and did not include a lot of the regressive elements. They all came under the second Constituent Assembly, under this pressure of national identity. But I think that's the difference. National identity, they kind of reverted to that old style panchayat vision of nationalism, which is very gendered and very caste hierarchy based.
And I think from a broader kind of more theoretical perspective, it's kind of, there will always be kind of contradictions within the Constitution, as you mentioned, so tensions between rights, and sometimes judges have to kind of deal with that or resolve that tension. But here, it's not only that there's contradictions between provisions of the Constitution, but that there's a contradiction with the idea of transformation itself. So it's not, obviously some could see a contradiction, for example, between what I was talking about earlier, between preservative elements and transformative elements. So I tried to, in my mind, we were thinking about this idea of non-transformative kind of provisions, but then there are counter-transformative provisions, things that are actually push courts in the opposite direction. So, if a transformative constitution is pushing you towards substantive equality, but the Constitution itself says, essentially is enforcing formal equality, is pushing for formal equality, it kind of leaves you in this kind of conundrum where you're essentially, you're stuck between a rock and a hard place. And what makes it all the worse, I think, and what I was trying to get at in terms of talking about the South African context, is this idea of this language of transformative constitutionalism and transformative constitutions has had a really important role within South Africa in understanding what social rights do and can do and what courts can do. And so if you don't have that same kind of, I think it's provided kind of a support framework for South African judges to say, we can do this, we can go this far, we can do more with social rights because we're in a transformative constitution. But a court, like a Nepali court, that doesn't have that same kind of cushion or framework is stuck kind of in a difficult position, because they can't say, we have a clearly transformative constitution and a commitment to substantive equality. We actually have the opposite. So what can we do with our social rights provisions if we have an obligation to enforce them as protectors or enforcers of the Constitution, but we don't have that transformative language to rely upon. Does that make sense?
Yeah, no, that's really interesting. Yeah.
Okay, well, I think we're officially out of time, but thank you very much. It was a really interesting discussion of the transformative features as well as the not so transformative elements, especially of the Nepali Constitution. And we really appreciate coming and sharing with us. Thank you. Substantive equality as well, and it's actually even more formal equality.
Yeah.